Welcome to Concerned Citizens Presents. Concerned Citizens of Laguna Woods is an organization dedicated to peace, economic and social justice, good government, and a clean environment. Every month, we invite an expert to enlighten us on a topic related to our mission. Because Village TV videotapes these presentations, we can share that expertise with a larger audience. We hope you enjoy today's broadcast.
Good afternoon. Good afternoon, Dean Chemerinsky and audience of concerned citizens. My name is Suzanne Modell. I'm president of Concerned Citizens, and I'm thrilled to welcome you all for this enlightening afternoon. Our guest today is Dean Erwin Chemerinsky, Dean of the Berkeley Law School and previously Dean of the UC Irvine Law School. He is the most cited U.S. constitutional scholar and a former president of the American Association of Law Schools. I will not introduce him further since I'm sure you all know all about him, and I want to give him maximum time. So he will speak about his new book, Worse Than Nothing, The Dangerous Fallacy of Originalism. And if we're lucky, we'll get a few questions in at the end before he leaves us. Dean Chemerinsky.
Thank you so much. It's a pleasure to speak with you. I wish I could be with you in person. So I used to come when I was in Orange County, but I appreciate you allowing me to speak by Zoom. In 1987, Robert Bork was rejected for a seat on the United States Supreme Court by the largest margin of any nominee in American history. 58 senators voted against Bork. Bork was impeccably qualified. He had been a Yale law professor, the Solicitor General of the United States. At the time of his nomination, he was a judge on the United States Court of Appeals for the District of Columbia Circuit. Why then was he rejected, and rejected resoundingly? The reason is his originalist views were deemed unacceptable. Originalism is the perspective that the meaning of a constitutional provision is fixed when it's adopted and can be changed only through the amendment process. Bork, following his originalist philosophy, said there is no right to privacy under the Constitution, and the Supreme Court was wrong in Griswold versus Connecticut, in protecting the right to purchase and use contraceptives, in Roe versus Wade, protecting the right to abortion. Bork said there's no protection for women against discrimination under the Equal Protection Clause. Said the Equal Protection Clause was originally meant just to deal with race. He said the First Amendment only protects political speech, not speech for entertainment, not commercial speech, because that's all he saw in the original meaning of the First Amendment. Ted Kennedy very famously gave a speech about what Bork's philosophy would mean for people in this country. Originalism was regarded as a fringe and dangerous theory. Now it's very much come into vogue. There are 3 justices on the current court, Clarence Thomas, Neil Gorsuch, and Amy Coney Barrett, who are self-avowed originalists. 3 other conservative justices, John Roberts, Samuel Alito, and Brett Kavanaugh, will often join the originalist decisions or write their own in originalist language. Donald Trump picked about a quarter of all of the lower federal court judges now on the bench. And many of these too are self-avowed originalists. So what I decided that I wanted to do was to write a book explaining the fallacies of originalism. The title comes as a response to something Justice Antonin Scalia, one of the foremost proponents of originalism, said. He would say frequently, I have a theory, originalism, they don't. Well, this led me to decide I wanted to say that his theory is, in the title of the book, Worse Than Nothing, The Dangerous Fallacy of Originalism. Well, at first blush, originalism has appeal. Why shouldn't we just discern and follow the original meaning of the Constitution. In the book, I identify many flaws with regard to originalism. The first I would call the epistemological problem. The reality is we can't know what people thought in 1787 or 1791 or 1868 when the 14th Amendment was passed, even if we wanted to follow it. The reality is so many people were involved in drafting a constitutional provision, in ratifying a constitutional provision. It's impossible to say there was a collective original intent. So, for example, when we talk about the drafting of the first 7 articles of the Constitution in 1787, there were 55 individuals who participated in the Constitutional Convention. All were white men. 45% of them were slave owners. And then after they proposed a constitutional provision with the Constitution of the United States, it went to the states for ratification. Many people participated in the state ratification conventions. How do we decide what the original meaning was of such a large group of people? When originalism was first developed as a theory in the early 1970s, it was a conservative response to the Warren Court. Robert Bork wrote one of the first articles advancing originalism, and it was very much about criticism of the Warren Court. Originalism especially came into vogue after Roe versus Wade in 1973, as conservatives embraced it as a way of challenging the Supreme Court's decision in Roe. When originalism was first developed, it focused on the framers' intent. There was a lot of talk about what did James Madison or what did Alexander Hamilton think at the time. But they, of course, were only 2 of the people at the Constitutional Convention, and they were only one state ratifying convention, or one was in New York and one was in Virginia, but they're just 2 people. Criticisms developed about the impossibility of knowing the framers' intent, and then originalists shifted to a different approach, and they said, what we'll determine is the original public meaning of a constitutional provision. But that's just as elusive as trying to find the framers' intent. It assumes that there was an agreed upon original public meaning. And conservative justices still shift back and forth between these 2 forms of originalism. A year ago, the Supreme Court decided a case, Kennedy versus Bremerton Schools. It involved whether a high school football coach could go on the field after games and publicly pray. Now, for 60 years, the Supreme Court has said that prayer in public schools in all of its forms violates the Establishment Clause of the First Amendment. The Supreme Court, though, said to deny the football coach of the ability to kneel and pray violated his free exercise of religion and his freedom of speech. The court rejected any concern that allowing the prayer would infringe the Establishment Clause. Justice Gorsuch, writing for the court, said, we determine what's permissible or what violates the Establishment Clause by looking, quote, to the founders' views, saying, we look to see whether or not this would violate the Establishment Clause by looking at what the drafters of the First Amendment thought in 1791. As I'll talk about more, just to ask that question shows its absurdity. Here's the question. What did the framers in 1791 think about a public school football coach going onto the field after game? Just to ask the question shows the absurdity of looking to the original meaning of 1791 to answer questions that apply today. This epistemological problem is something that I saw firsthand. In 1997, I was elected by Los Angeles voters to be part of a 15-person commission to rewrite the city charter of Los Angeles. A charter for a city in California functions very much as a constitution for that city. It creates the institutions of city government. It allocates power among them. It even protects more individual rights than the US Constitution or the state constitution. It was an arduous 2-year process. We would take tentative votes on issues and then come back and take more final votes. And inevitably, we disagreed about what we had decided earlier. We finally came up with our proposal, but there was another commission in the city at the time appointed by the city council, and we had to work out compromises with them. Ultimately, it all went before the voters in June of 1999. Almost as soon as it was approved by the voters then, and as soon as it went into effect, issues began to arise over what we meant with a particular provision. Almost inevitably, the answer to the question was, we hadn't thought about it. It was an issue that hadn't come up in our deliberations. The first case to be litigated under the charter involved the meaning of a term limits provision, and it involved somebody who had previously been in the city council and now wanted to return. And I was called by both sides of the litigation and said, we just never contemplated that situation. There was no intent. Well, the California Court of Appeal decided the case and said the voters' intent behind the provision was, this was one sentence in a 100-page document. There was no voters' intent for it. That was a fiction. I still get calls from time to time over what the Charter Commission intended for a particular provision. Occasionally, I have a recollection, and if it's what the lawyer wants to hear, they say, would you write a declaration? If it's not what the lawyer wants to hear, they'll keep calling other Charter Reform Commission members till they get somebody to say what they want. At the time we wrote the charter, and for a number of years, thankfully, all of us were still alive. But still the practice exists of trying to figure out what was intended by this commission 25 years ago. To me, it so reflects the epistemological problem. Originalism assumes that there is an original meaning to be defined. There is an original meaning that can then be followed. And for so many provisions of the Constitution, it just doesn't exist. There is a second problem that I would identify with regard to originalism, and that's that I think it's a theory that's self-defeating. Let me explain what I mean here. Originalism says that courts should follow the original intent behind a constitutional provision. We generally would say courts should follow the original understanding behind the Constitution. The problem with that is that the framers of the Constitution clearly did not want their intent to be controlling. James Madison took the only notes at the Constitutional Convention, and he directed they not be published until after his death. The delegates agreed early on that all of the deliberations would be in secret and confidential. It's clear that the framers intended to write a constitution that would be adapted through interpretation. Lest you think this is just hindsight from July of 2023, in 1819, in McCulloch versus Maryland, Chief Justice John Marshall, who himself had been at the Constitutional Convention, said, and I quote, "We must never forget that it's a constitution we're expounding, a constitution meant to endure and adapt for ages to come." The framers knew that the only way for their constitution to survive would be to have it through interpretation applied to modern circumstances and needs. That's why they wrote so much of the Constitution in very broad, open-ended language. What's due process of law? What's cruel and unusual punishment? What's freedom of speech? They didn't want their conceptions from the 18th century to control. They wanted to be a constitution that would gather meaning into the future. Well, that's what makes originalism self-defeating. Because if you were to follow the original intent behind the Constitution, it was that the original intent shouldn't be controlling. If one wanted to follow the framers' intent on this, one would have to abandon originalism. Another aspect of this problem is that the question of originalism is largely about how should courts go about interpreting the Constitution and deciding the cases that come before them. But it's unclear whether the framers even wanted courts to be able to declare laws unconstitutional. There is no provision in the Constitution that says that the Supreme Court and the federal courts can review federal statutes or executive actions to determine their constitutionality. One would think if the framers wanted to create such a power, they would have said so explicitly in the Constitution. No court in England, then or now, has the ability to declare laws unconstitutional. Where the framers were departing from English law, they specified that that's what they were doing. And yet they don't in the Constitution anywhere say that courts have the power to declare laws unconstitutional, or courts have the power to declare executive acts unconstitutional. So the question then is, what did the framers think that courts should do when they're evaluating the constitutionality of statutes or executive actions? That question is incoherent because the framers never discussed, never provided for in the Constitution judicial review. So in fact, if one really wanted to follow originalism, a strong argument that judicial review shouldn't exist at all. And then it makes no sense to answer the question, how should judicial review be done? And should it be done from an originalist perspective? The third problem that I would identify with originalism, I call the abhorrence problem. If we were to follow originalism, it would lead to truly abhorrent results. Think for a moment about Brown versus Board of Education, or Loving versus Virginia, that said that states can't prohibit interracial marriage, or Obergefell versus Hodges, that said states can't prohibit same-sex marriage, or about the Constitution's prohibition, discrimination based on sex or sexual orientation, or about the Second Amendment. I would suggest to follow the framers' views on these areas would lead us to results that almost everyone, or at least the vast majority among us, would regard as abhorrent. Let me start with Brown versus Board of Education. To me, Brown versus Board of Education, the decision of May 17th, 1954, is the epitome of why we have a Supreme Court. There, the Supreme Court held that separate can never be equal in the realm of public education, that laws that mandate segregation of the races in public schools are unconstitutional. Yet I think it's impossible to justify Chief Justice Warren and the court's conclusion from an originalist perspective. The same Congress that voted to ratify the 14th Amendment also voted to segregate the District of Columbia public schools. It seems clear that it meant to allow, not to prohibit, segregation. And there were briefs filed in the Supreme Court that argued just this. From an originalist perspective, though the term originalism didn't exist then, Brown versus Board of Education should have come out the other way. Loving versus Virginia. In 1967, not that long ago, Virginia and 15 other states had laws that prohibited interracial marriage. That was the issue in Loving. From an originalist perspective, those laws were constitutional. When the 14th Amendment was adopted, almost all states had such laws. Yet California had a law prohibiting interracial marriage until 1948. Nonetheless, the Supreme Court appropriately gave no weight to the original meaning. Again, Chief Justice Warren wrote for the court and very eloquently found that laws that prohibit interracial marriage violate equal protection, infringe the right to marry. Following that, on June 26, 2015, in Obergefell versus Hodges, the Supreme Court said that state laws that prohibit same-sex marriage violate equal protection and deny due process. Court based this part on Loving versus Virginia. Well, obviously, there was no right to same-sex marriage through most of American history. There's no indication that the framers of the 14th Amendment or of the Constitution meant to create a right to same-sex marriage. As recently as 1961, all 50 states in the District of Columbia had laws that prohibited private, consensual, same-sex sexual activity. Nonetheless, Obergefell is a landmark in advancing liberty and equality, but it certainly couldn't be justified from an originalist perspective. Or think about discrimination on the basis of sex or sexual orientation. Justice Scalia was fond of saying there was nothing in the Constitution that prohibited sex discrimination because the Equal Protection Clause of the 14th Amendment was meant only to apply to race discrimination. There was also, as I mentioned in my introduction, a position of Robert Bork, and one of the reasons that he got rejected for a seat on the United States Supreme Court. It seems to me unacceptable to think that the government can discriminate based on sex or sexual orientation with impunity, and yet that would be the originalist perspective. Or let me take the example of guns. And here, let me talk about a case that's going to be argued in the Supreme Court this fall. A year ago, on June 23rd, 2022, the Supreme Court decided New York State Rifle and Pistol Association versus Bruin. It involved New York law initially adopted in 1907 that says in order to have a gun in public, a person will need a permit. To get a permit, a person will need to show a safety need for having the gun. The Supreme Court, in a 6-3 decision, declared the New York law unconstitutional. Justice Thomas wrote for the court. This was the first time the Supreme Court ever said that there was a Second Amendment right to have guns in public. But then the Supreme Court went even further. Justice Thomas said the only type of gun regulations are allowed are those that were historically permitted. For every other right in the Constitution, the government can infringe if it has a compelling interest, and there's no other way to achieve it. But Justice Thomas said, we're not going to be concerned. It's irrelevant whether there's a compelling interest, relevant whether there's no other way to achieve it. So all that will matter is this the type of regulation that was historically permitted? Well, this past winter, the Federal Court of Appeals in New Orleans, the United States Court of Appeals for the Fifth Circuit, decided a case called United States versus Rahimi. It involves a federal law that says that if a person is under a restraining order in a domestic violence case, they cannot have a firearm. This is a law that unquestionably has saved many women's lives. But the United States Court of Appeals for the Fifth Circuit declared it unconstitutional. The Fifth Circuit said, in light of Bruin, the only question is this the type of law that existed historically? Well, in 1791, there weren't laws like this. In 1791, there weren't restraining orders with regard to domestic violence. In 1791, married women were considered the chattels, the property of their husband, and didn't have rights at all. Why should what the government can do now to protect people be limited to just what people were thinking in 1791? The Supreme Court has granted review in the Rahimi case. It'll be heard in the fall. And I hope very much that the Supreme Court reverses the lower court. You might have seen about a month ago, a federal district court in Mississippi declared unconstitutional a federal law that makes it a crime for a convicted felon to have a firearm. The judge, Carlton Reeves, said, I have to look at just what was historically allowed in 1791, and there weren't such laws then. To me, all of this is the abhorrence problem. If we were to follow the framers' intent, it would get us to results that I think all, or at least most of us, would emphatically reject. I don't know if you heard me talk about the Rahimi case. Yeah. It involves a federal law that makes it a crime for someone in a restraining order in a domestic violence case from having a gun. Yeah. And the Federal Court of Appeals said, well, those laws didn't exist in 1791, so we can't have that law today. That to me is an abhorrent result. Of course, the government should be able to keep those with restraining orders and domestic violence, keeping guns in the case before the Supreme Court. A fourth problem with originalism is what I'd call the modernity problem. There are so many issues that the framers couldn't possibly have contemplated in 1791. It makes no sense to even look for the answer. Let me give examples of this as well. I can start with an anecdote. About a decade ago, the Supreme Court had before it a case that involved a California law that said it was a crime to sell or rent a violent video game to a minor without parents' consent. And Justice Scalia was pressing the advocates about this. And finally, Justice Alito interrupted and said, what Justice Scalia really wants to know is, What did James Madison think about violent video games? Just to ask the question is to show the absurdity. But let me make this concrete with an example that I think shows the problems with originalism being applied to modern technology. It's a case from 5 years ago, Carpenter versus United States. And the issue is, do the police need a warrant in order to get cellular location information? I'll explain. Whenever our phones are on, they automatically connect with cell towers. And as we travel from one place to another, our phones automatically shift from one cell tower to another. It's therefore pretty easy to figure out where somebody was at a moment in time with a fair degree of precision by getting the cellular location information. What's involved here is Timothy Carpenter was involved in a number of armed robberies. Ironically, many of them were of Radio Shacks, though now I need to explain to my students what a Radio Shack is. But there's a major case, the Supreme Court, involving the Fourth Amendment and phone booths, and I have to explain to my students what a phone booth is as well. The police went to the cell company and got 127 days of Timothy Carpenter's cellular location information. And they were able to show that every time there was one of these robberies, Timothy Carpenter was nearby based on his cellular location information. And Carpenter objected to this and said, the police didn't have a warrant to get my cellular location information. Therefore, it violated the Fourth Amendment. The judge rejected that argument. Carpenter was convicted and sentenced to 119 years in prison. Carpenter appealed, and the Supreme Court 5-4 ruled in his favor. It's interesting that the 5 in the majority were Chief Justice Roberts, joined by Justices Ginsburg, Breyer, Sotomayor, and Kagan. I don't know that the case would come out the same way today. Chief Justice Roberts said, the Fourth Amendment is based on whether somebody has a reasonable expectation of privacy. He said, we have a reasonable expectation that the police aren't going to obtain 127 days of cellular location information without having a warrant. Chief Justice Roberts said, you can learn a great deal of private information about somebody. You can find out what doctors they visit, where they worship, they go visit, and the like. And the Supreme Court said, you need to get a warrant before obtaining this. Justice Thomas wrote a dissent. Remember, he's a foremost originalist, in which he disagreed. He said, from an originalist perspective, that's not what the Fourth Amendment means. He said the Fourth Amendment was adopted meant only that the police could not physically trespass onto somebody's property without a warrant. So that's all it should be about today. And the police didn't physically trespass onto Timothy Carpenter's property. So no Fourth Amendment violation, no warrant needed from Justice Thomas's perspective. Think about the technology that exists that allows the police to gather information about us without needing to trespass on our property. They can tap our phones now without going onto our property. They can, as this case shows, track our cell phones where they are without needing to go on our property. There's certainly now satellite technology that would allow them to gather information about us without going on our property. Justice Thomas's approach would limit the Fourth Amendment to just what it meant in 1791. And that's what I mean by the modernity problem. It makes no sense given the technology as it's advanced, given the times that we live in. I mean, I could give other examples that I would say illustrate the absurdity of applying a constitution written in 1787, Bill of Rights in 1791 to modern circumstances. Think of Article 2 of the Constitution. It refers to the president and the vice president with the pronoun he. I can show you quotes that the framers thought that the president and the vice president would only be men. The women weren't given the right to vote under the Constitution until the 19th Amendment was adopted in 1920. Does that mean it was unconstitutional to elect Kamala Harris as vice president until the Constitution was amended? because that wasn't part of the original intent of the framers. To me, again, this is about showing the absurdity of originalism when you try to apply the views of 1787 to the 21st century. There's no provision in the Constitution that says the federal government can't deny equal protection. The 14th Amendment says no state shall deny any person of equal protection laws. But there's nothing in the Constitution about the federal government. Does that mean that the federal government can discriminate however it wants and can never be challenged? That makes no sense. But that's, again, all about trying to just be originalists. There's a fifth and final problem that I would identify with regard to originalism, and that's what I would call the hypocrisy problem. The conservative justices abandon originalism when it doesn't get to the conservative results they want to come to. Again, let me give you a couple of examples. The first of these is a case that I've spoken with you about before, Citizens United versus Federal Election Commission. There's a decision in 2010 where the Supreme Court held that corporations have the right to spend unlimited amounts of money to get candidates elected or defeated. Justice Ginsburg gave a speech in San Diego not too long after the decision, in which she said, this will be regarded as one of the worst Supreme Court cases in history. I think Justice Ginsburg was right. Justice Ginsburg pointed out that corporations, as we think of them today, didn't exist in 1791. More important, campaign spending as it exists today wasn't there in 1791. If you're an originalist, how can you possibly say, from the perspective of the original meaning of the First Amendment, that corporations have the right to spend unlimited amounts of money in election campaigns? Nonetheless, the 5 conservative justices in a 5-4 decision, with all of the originalists just in the majority, struck down the McCain-Feingold Campaign Finance Reform Act, limit the ability federal, state, and local governments to adopt campaign finance laws. There's now a pretty substantial body of political science literature that shows how much Citizens United has made a difference in elections, not for presidential elections. So much money is spent on both sides there, but especially state and local elections, elections where there's less name visibility. These are elections where spending a large amount of money can really change the outcome. Another example of this, what I call the hypocrisy problem, is a Supreme Court decision that came down just a few weeks ago, on Thursday, June 29th of this year, and it involves affirmative action. The case is Students for Fair Admission versus President and Fellows of Harvard College. In 1978, in Regents of the University of California versus Bakke, Justice Lewis Powell wrote a pivotal opinion saying that colleges and universities have a compelling interest in having a diverse student body. Colleges and universities can use race as one factor in admissions decisions to benefit minorities and enhance diversity. In 2003, in Grutter versus Bollinger, the Supreme Court reaffirmed that in an opinion by Justice Sandra O'Connor. In 2016, in Fisher versus University of Texas at Austin, the Supreme Court reaffirmed that colleges and universities have a compelling interest in having diversity in the classroom and on campus. They can use race as one factor among many to enhance diversity to benefit minorities. However, in Students for Fair Admission, the Supreme Court effectively overruled those cases. Chief Justice Roberts wrote for the court and said no longer can college universities engage in affirmative action. No longer can college universities use race as a factor in their admissions decisions to benefit minorities. What I want to focus on here is the decision from an originalist perspective. And this is a point that both Justices Sotomayor and Jackson made in their dissents. The same Congress that ratified the 14th Amendment also adopted a number of race-conscious programs. These are programs that today we would call affirmative action. The Freedmen's Bureau, for example, was specifically about benefits that were racially focused. There were programs that existed to help Black veterans of the Civil War that were racially focused. So if what we're looking at is what was the original meaning of the 14th Amendment, it seems clear. It was to allow affirmative action. But the conservative justices give that original meaning no weight. This is what I mean when I say that there's hypocrisy. When originalism doesn't get to the results that the conservatives want, they abandon originalism and follow their conservative judicial philosophy. So this is why I wrote in the book that originalism is a dangerous fallacy. But what's the alternative to originalism? What I suggest to you is that throughout American history, the Supreme Court has looked to a number of different sources in interpreting the Constitution. All of the justices start with the text of the Constitution, but the reality is the text rarely provides answers for the issues that come before the Supreme Court. As I said, what's due process of law? What's cruel and unusual punishment? What's free exercise of religion? After the text, certainly all justices will look to see, was there an original understanding of the meaning of a constitutional revision? Liberal justice would say, we should see what it is. That doesn't mean we have to follow what they thought in 1787 or 1791. It's only conservative originalists who say the Constitution's meaning is limited to those conceptions. We should look to the structure of the Constitution. What does it tell us? We should look at history and tradition. We should look at precedent. The current court gives so little weight to precedent, and precedent is vital for stability and predictability in the law. And we should look to modern social needs. I mentioned to you, and hopefully this wasn't when I was cutting out, that last year the Supreme Court decided New York State Rifle and Pistol Association versus Bruin. Justice Breyer began his dissent by talking about the toll of gun violence in the United States. He presented statistics about it. He talked about the recent mass shootings. Justice Alito wrote a concurring opinion where he mocked Justice Breyer for doing so, saying all of that is irrelevant. But it's not irrelevant. We need to interpret the Constitution for the society we live in today, and modern social needs are relevant. Admittedly, when you look at a number of different sources, there's not going to be a clear, determinate answer to cases. But there's not a clear, determinate answer when it comes to originalism either. What was the original meaning of a provision? People can disagree. Inevitably, they'll find in the original meaning the conclusion that they want to come to. This has been referred to as law office history. That instead of doing what a historian would, exploring and seeing what conclusions, what ends up happening is, with originalism, lawyers will look at the historical record to find what supports their view. Justices will look at the historical record to see what supports their view, but they're still coming to the conclusion that they want. There is no way to have justices decide cases, or often judges decide cases, apart from the values of who's on the court. The reason we have the decisions we do, overruling Roe versus Wade, ending affirmative action, allowing people to discriminate, violation of anti-discrimination law on account of their beliefs, is that Donald Trump was able to put 3 justices on the Supreme Court. If Hillary Clinton had become president after 2016, and she had filled those 3 vacancies, Roe versus Wade would still be the law. Affirmative action would still be allowed. People wouldn't be able to discriminate in violation of state law on account of their beliefs. It always has been about the value of the justices. I have another way of explaining this that I alluded to earlier. Almost no rights in the Constitution are absolute. For the most basic rights, the government can interfere if it has a compelling interest and no other way to achieve it. But what's a compelling interest? The Supreme Court's never said. The government can discriminate based on race if it has a compelling interest. The government can infringe freedom of speech if it has a compelling interest. But what's a compelling interest? All infringement of liberty, any discrimination on any grounds, has to at least be rationally related to a legitimate purpose. But what's a legitimate purpose? What's compelling or important or legitimate is very much based on who's interpreting the Constitution. The Fourth Amendment prohibits unreasonable searches and seizures. But what does unreasonable mean? There's no way to have value-neutral judging. I conclude the book by talking about why I think originalism is dangerous. There are so many rights that are protected under the Constitution that can't be justified from an originalist perspective. I've alluded to some already. The right to marry. The Supreme Court said the right to marry means states can't prohibit interracial marriage or same-sex marriage. The right to procreate. The Supreme Court has said that state laws that impose involuntary sterilization are unconstitutional. The right of parents to custody of their children. The right to keep the family together. The right of parents to control the upbringing of their children. The right to purchase and use contraceptives. The right of consenting adults to engage in private, consensual, same-sex sexual activity. The right of competent adults to refuse medical care. All of these have been protected by the Supreme Court, even though they can't be justified from an originalist perspective. I finished the book Worse Than Nothing in the summer of 2021. And one of the predictions that I made was that the Supreme Court, following originalism, would soon overrule Roe versus Wade. That came to be true. And as you know, on June 24th, 2022, in Dobbs versus Jackson Women's Health Center, the court overruled Roe versus Wade. Justice Thomas, an originalist, in a concurring opinion said, now that we've overruled Roe, we need to overrule Griswold versus Connecticut, the Supreme Court case that held there's a right to purchase and use contraceptives. Lawrence versus Texas, the case that said that states can't prohibit consenting adults from engaging in private same-sex sexual activity. And Obergefell versus Hodges, the case that said states can't prohibit same-sex marriage. Justice Alito, in his majority opinion, said that those rights aren't in danger because they don't involve potential life. But if one takes an originalist perspective, if one takes the framework that Justice Alito articulated, then none of those rights can be justified. Justice Alito, in the beginning of the opinion in Dobbs, said a right is protected only if it's in the text of the Constitution, part of the original meaning, or a long, unbroken tradition, likely have to extend back to the framing of the Constitution. None of the rights that I elaborated for you meet this. And so I worry that Justice Thomas here was telling us what we can expect in the future. If we follow originalism, all of those are rights that we would lose. So my bottom line is, it makes no sense for this country in 2023 to be limited to the meaning of what those thought for an agrarian slave society in 1787. That the only way for the Constitution to govern us is, as John Marshall said, for it to be adapted and endure for ages to come through the interpretation process. So that's why I wrote the book, and that's my summary of it. I did, as you asked me, to save time for questions. I'm glad to talk about originalism. I'm also glad to talk about cases from this term in the Supreme Court.
Well, thank you very much. Since our time is limited, we have some prepackaged questions for you.
Great.
Well, I'm trying to extemporaneously. You surprised me by talking about U.S. versus Rahimi because I wanted to ask you about it. Maybe just for the audience, I'll run through quickly. It's a case about whether we can forbid domestic abusers from using guns. You mentioned it. In 2021, while searching Mr. Rahimi's home, police found a rifle and a pistol. At that time, he was under a restraining order that forbade him from possessing firearms because he had threatened to shoot his girlfriend. Rahimi pleaded guilty to illegal possession and went to jail. However, last year, the Supreme Court ruled that restrictions on guns had to be, quote, consistent with the nation's historical tradition of firearm regulation, unquote. Rahimi appealed his conviction and it was reversed. Now, the Biden administration is appealing the reversal on the grounds that there is, quote, strong historical evidence supporting the principle that the government may disarm dangerous individuals. So there you have it. I understand that far-right conservatives are concerned that the court will split on this and that actually they may allow the law to restrict the use of guns to domestic abusers, while liberals are terrified that in fact the situation may remain as it currently is. So I wondered if you could talk about why the Supreme Court took the case and how you expect them to rule.
I think you summarized it well. In Bruin, the Supreme Court said the only kind of gun regulations be allowed are those that were historically permitted. So in the Rahimi case, the Fifth Circuit said there weren't historically restrictions on those in restraining orders in domestic violence cases involving guns, so this law is unconstitutional. To me, that shows the absurdity of originalism. Our attitudes towards domestic violence were so vastly different in 1791 than in 2023. There weren't restraining orders of this sort in 1791. I obviously don't know what the Supreme Court will do. I long ago learned that he who lives by the crystal ball has to learn to eat ground glass. But my prediction is that the Supreme Court's going to reverse the Fifth Circuit because it's just absurd to not say this law is constitutional. I think what the Supreme Court will say is in 1791, there could be restrictions of dangerous individuals having guns. This is an extension of that. And therefore, we should be able to allow the restriction now. Of course, that just shows the indeterminacy of originalism. But I'm hopeful the Supreme Court will reverse the Fifth Circuit. I'm hopeful that they will uphold the law. But I see why, based on Justice Thomas' opinion in Bruin, the Fifth Circuit came to this conclusion.
Okay, let me ask a couple more. If, as originalists have argued, there is no constitutional right to privacy, isn't the decision allowing citizens to carry a concealed weapon a decision in favor of privacy?
It is, but I think what a conservative justice would say is the right to keep and bear arms is explicitly protected by the Second Amendment. And so the right to have a concealed weapon comes within the Second Amendment. But when it comes to privacy rights, the rights of autonomy that I was mentioning, they would say none of those are in the Constitution. They'd say, see, the Second Amendment is the text. Privacy is not in the text. Therefore, be treated totally differently.
Okay. Considering the cherry picking of history that originalist judges and justices engage in when legitimating their decisions, do you think it would be useful to implement Kenneth Culp Davis's 1986 proposal that the Supreme Court asked Congress to, quote, create a research organization outside the court to make studies at the court's request? In other words, would it be helpful to provide the Supreme Court with a team of historical investigators, something like the Congressional Research Service?
Some lower court judges are now appointing professors of history to be experts to advise them. There's a member of the history department here at Berkeley who's been contacted about a half dozen times in Second Amendment cases just over the last year to be an expert. Justice Breyer, in his dissent in Bruin, pointed out that justices and judges aren't trained as historians. So I guess if we're going to go in this direction where everything turns on historical understanding, maybe it would be good to have a group of historians. The problem is, of course, there's no such thing as neutral history. Historians would tell you that inevitably history is about interpretation. So I worry about who are these people who are going to deemed to be the authoritative historians.
Okay, last one. Suppose a Christian family maintains that their religion holds Jews collectively responsible for the killing of Christ. The family wishes to open a restaurant. However, given these negative feelings, they don't want to serve Jews. More precisely, they seek an exemption to the 1964 Civil Rights Act because serving Jewish customers conflicts with their religious teachings. If today's Supreme Court chose to hear this case, how do you think they would rule?
This goes to the Supreme Court's decision from June 30th in 303 Creative versus Elenis. What's involved there is a woman, Lori Smith, has a business of designing websites. And she wants to expand it to do websites for weddings, but she doesn't want to do websites for same-sex weddings because of religious beliefs. Colorado has a law, as does California, that prohibits business establishments from discriminating based on race or sexual orientation. And Lori Smith says, it violates my free access religion and my free speech to have me to design a website for same-sex couples. The Supreme Court didn't focus at all on the free access question, but the Supreme Court said to force Lori Smith to design websites that she doesn't believe in is impermissible compelled speech. It violates the First Amendment. So if in your hypothetical, those individuals are engaged or regarded as expressive activity, then they have the right, based on their beliefs, to refuse service, even in violation of the 1964 Civil Rights Act. Just last week, a hairdresser in Minnesota said, cutting hair is my expressive activity. Therefore, I can discriminate. And there's certainly been cases at weddings of those who design and bake cakes or arrange floral arrangements or do videos and photographs or engrave stationery, saying it's all expressive activity. We don't have to serve those that we don't want to, where it violates our beliefs. And we can certainly see this extended to, say, cabinet makers, hairdressers, or in your example, those who prepare food. Maybe I can put this another way. There's always a tension between liberty and equality. Any law that prohibits discrimination, by definition, limits the freedom to discriminate. For decades, the Supreme Court has said, stopping discrimination is more important than protecting a freedom to discriminate. What's so troubling about the 303 Creative case, in your hypothetical, is the Supreme Court has now said there is a First Amendment right to discriminate, and it creates a First Amendment exception to anti-discrimination laws.
Well, thank you so much. We've all absolutely loved listening to you. And for those of you who wish to learn more, we have, Jonathan, would you hold up the book? This is a marvelous book. And as all your books are, beautifully written, straightforward, for the educated layperson, enormously informative. So thank you, and perhaps we can have you again next year.
Thank you.